Picture this. You and your spouse just walked out of what felt like a successful green card interview. The officer was polite, asked a few questions, and even seemed convinced your marriage was real. But then, the very next day, you receive a letter demanding you come back to sign papers you've never heard of. What's going on here, and why are marriage-based green card cases suddenly facing new levels of scrutiny? The new twist in marriage-based green cards. For years, applicants in marriage-based green card cases could expect a straightforward process: file Form I-130, show up to the adjustment of status interview, and, if all looked good, wait for approval. But as of mid-2025, USCIS has begun enforcing rules that most couples never even hear about until they're suddenly caught in the middle of them. One of the biggest surprises comes when a marriage is entered into while the immigrant spouse is in removal proceedings. Even if those proceedings are later dismissed, the couple must still submit what's called a bona fide marriage exemption waiver. Without it, your case can stall or even be denied. The real case example. At New York City's Federal Plaza, one couple thought their process was almost over. The interview was smooth. The officer didn't pry into their relationship, didn't grill them about details, and seemed convinced everything was genuine. They left feeling relieved until the very next day, when the U.S. citizen's spouse received a sudden notice to return, bringing her state ID. For many, a callback like this sparks panic. Was it a trap? Were they about to dig into old marriages, prior petitions, or even initiate denaturalization proceedings? In some cases, attorneys report that USCIS does use callbacks for deeper investigations, and yes, people with outstanding warrants have even been arrested at these offices. But in this particular case, it was something else entirely. The couple had never submitted the required exemption waiver because they filed their I-130 while removal proceedings were still active. The officer simply needed the U.S. citizen spouse's signature on that waiver to move the process forward. Why this matters for you? This may sound like a technicality, but it's more than paperwork. It shows how minor oversights can create major risks under today's stricter immigration climate. USCIS isn't always going to send you a polite request for missing documents anymore. Instead, cases can be denied, delayed, or flagged for fraud investigations if everything isn't done properly up front. Increased risks at USCIS interviews. While outright arrests at green card interviews are still rare, they do happen. Applicants with old removal orders, criminal records, or suspected fraud are at the highest risk. Even couples with legitimate marriages are finding themselves under unexpected scrutiny. And in the wrong situation, just being in that federal building can feel dangerous for the immigrant spouse. That's why many attorneys now advise U.S. citizen spouses to attend interviews alone if they're the ones specifically called back. It reduces unnecessary risk until it's clear what USCIS actually wants. The policy shift behind the scenes. For decades, if you forgot to include a document or signature, USCIS would send a request for evidence, RFE, or a notice of intent to deny, an OID. That buffer gave couples a chance to fix mistakes. But starting in 2018 and reinforced under current rules, officers gain the discretion to deny cases outright without giving applicants a second chance. Now, instead of a warning letter, you may just get a denial. That's why it's no longer enough to be close enough when submitting your application. Every form, signature, and piece of supporting evidence has to be complete and consistent from day one. Common triggers for delays and denials. Filing while in removal proceedings without the required waiver. Inconsistent details between forms, like mismatched addresses or travel dates. Weak evidence of the marriage, such as few joint documents or one-dimensional photos. Financial shortfalls in the affidavit of support, especially among self-employed sponsors. Failure to disclose prior immigration history, like overstays or old denials. Each of these can create suspicion, and suspicion is all USCIS needs to slow your case or block it completely. Here's the bigger picture. Immigration law itself hasn't changed much in 2025, but the culture inside USCIS has. Officers are under pressure to spot fraud, limit approvals, and tighten enforcement. That doesn't mean they assume every marriage is fake, but it does mean the margin for error is razor thin. Where once the system allowed for flexibility, today it rewards only airtight cases. If your application leaves questions unanswered, officers may default to no rather than giving you a chance to explain later. Lessons from this case. The couple at Federal Plaza ultimately had nothing to fear. They signed the exemption waiver, and their case continued. But this could have gone differently. Without legal guidance, they may have panicked, sent the immigrant spouse inside unnecessarily, and risked detention. The lesson? Even simple situations can take unexpected turns. Knowing the rules, like the requirement for the exemption waiver, can mean the difference between a quick resolution and a devastating denial. What you can do now? Screen your case thoroughly. Before filing, check if any removal history, prior marriages, or prior filings could complicate things. Consult an attorney. Even if you can't hire one for the entire process, a consultation can reveal issues you might not see. Over-prepare for interviews. Bring more evidence than you think you need. Assume USCIS wants to see proof covering your whole relationship, not just snapshots. Know your rights. If you're called back unexpectedly, it's okay to bring legal representation and clarify what's being. Know your rights. If you're called back unexpectedly, it's okay to bring legal representation and clarify what's being asked before the immigrant spouse walks into the building. Stay updated. Policies are shifting faster than ever. Following trusted sources ensures you know about requirements like the bona fide marriage exemption before they catch you by surprise. Final thoughts. These are challenging times, but not hopeless ones. Most applicants with clean cases and well-prepared files are still being approved. The difference now is that success depends less on fixing problems later and more on getting everything right the first time. So, if you're starting your marriage-based green card journey, treat it like a one-shot opportunity. Prepare, double-check, and, when in doubt, seek professional advice. That's the best way to protect your future, your family, and your dream of stability in the US. If this video gave you clarity, don't keep it to yourself. Like this video, subscribe to Visa Intel USA for more updates, and share it with someone who might be filing soon. The more people know about these hidden requirements, the fewer lives will be derailed by preventable mistakes.